Okay, so good evening, class. I am Attorney Jazine Gail Paler-Acasio, and I will be your instructor for Law 2, Business Laws and Regulation, which covers three laws: partnership, the law on partnership, the revised corporation code, and cooperative law. So, this will be the book that we are going to use. This is by attorney Andrix Domingo. uh, I'm using the 2019 edition because of the revised corporation code. However, you may use the 2016 edition. But when we come to the lessons on the revised corporation code, then we will just have to incorporate the new amendments under the revised corporation code. Okay, so we go now to the law on partnership. The law on partnership is part of Book 5 of the new Civil Code. And in your Law 1, we discussed Book 4 of the new Civil Code, which is obligations and contracts. So, generally, partnership is a kind of contract. And Book 5 covers the nominal contracts or contracts which have names under the law. Okay. And the law on partnership covers Article 1767 until 1867. So basically, it consists of only 100 articles. But that is only for one part. We have corporation code and then we have cooperative law. Okay, so let's go to Article 1167. The article defines what is a partnership. So, unsa man din ang partnership? Partnership. So, in 1167, basically a partnership is a contract. So, in order for a contract to be considered a partnership, it must have four essential requisites. So that's in your book. Number one, there must be a valid contract, meaning there must be meeting of minds, there must be consent from the party, there must be a lawful object. Second, there must be contribution of money, property, or industry to a common fund. Now, this essential requisite is what makes partnership different from other kinds of contracts. So, contribution of what? Number one, money. What is money? Money is the medium of exchange that is recognized in a country. So, in the Philippines, of course, the money or the currency that is officially recognized is the Philippine peso. So, we say Philippine peso because there are other kinds of pesos in the world. Aside from Philippine peso, we also recognize the US dollar as our currency. Okay, so that is money. Property. When you say property, there are two kinds of property. It may be uh, movable or personal property or immovable or the real property. I believe we already discussed this in our obligations and contracts before. Although the law on property is book 2 of the new civil code. So again, when we say movable property or personal property, that is anything that is movable. It may be a cell phone, computer, or books. And when you say immovable property, it is attached to the ground. So we have the land, houses, buildings. These are what we call immovable property. So if you cannot contribute money, you can contribute property. Or if you cannot contribute both money and property, then you can contribute your industry. When you say industry, that is your expertise. So in order for a contract to be a contract of partnership, there must be contribution of money or property, money and or property and or industry to a common fund. Third, it must be organized for gain or profit. Again, this is a um, distinguishing what do you call this? Requisite of a partnership. So, ang purpose dyan nga nung nag-form mo og partnership is in order to gain, profit, kita. So, kung why kita, kung ang purpose ninyo is dili maka-gain, dili makaginansya, dili makakita, then that is not considered a partnership. And then, of course, lastly, it must be for a lawful object. Of course, anything under contracts. Now, if you remember, um, if the object is illegal or unlawful, it is a void contract and must be established for the common benefit of the partners. Okay, so those four are the essential requisites of a contract of partnership. So there are only two ways in order to determine whether um, there are two tests whether to determine if the contract is a partnership or not. Number one, there must be again the contribution of money, property, or industry. And second, it is the contract. The purpose of the contract was, or the organization of the said contract is for gain or profit. So if naana ng duha, then basically you can call the contract a partnership. Okay. So what is the characteristic of a contract of partnership? Of course, because it is a contract, it must be consensual. So when you say consensual, nagkasinabot. There must be consent from both parties. Commutative. When you say commutative, each of the partner must have their own contribution. Dapat na agad yung contribute kada partner, no? To form a community or a common fund. So, again, the contribution may either be money, property, or industry, or both, or all. And then it is a principal contract. What do you mean by a principal contract? It stands on its own. So, kung kutubra mo sa contract of partnership, pwede kutubra mo diha. Dili siya dependent on any other contracts. Fourth, it is bilateral. When you say bilateral, it is entered by two or more parties. And then it is onerous. Unsa man ang onerous? It gives an obligation, no, na siya gipatong obligation to the contracting parties, which is to contribute, no, katong contribution. That's what makes the contract of partnership onerous. And then it is also nominate. When you say nominate or a nominal contract, it is a contract which has a name in law. Ina may mga contracts nga ngan kay contract ra. But unlike our service contract, but unlike the uh, contract of partnership, nadali specific na mga articles sa balaod which specifically discuss the law on partnership. That is why it is nominate or considered a nominal contract. And then lastly, it is preparatory. So, 'di ba, ang purpose man sa partnership is to gain, 'di ba? To gain. So the moment you enter into a contract of partnership, it is in preparation to another contract. So you can enter into a contract of sale, contract of lease, and any other contracts. So preparatory contract siya. But what is the most important doctrine when it comes to the law on partnership? So you must remember this doctrine because by and by, going into the principles on the law on partnership, we will always go back to this doctrine. So, unsa man nga doctrine? Doctrine of delectus personae, no? Or delectus personarum, or delectus personae. What is this doctrine all about? Nganong diri man naka-anchor ang contract of partnership? This doctrine talks about the right to choose with whom a person wishes to associate himself. Meaning, if you want to enter into a contract of partnership, you have the right to choose your partner. Dili pwede magbuot ng balaod kung kinsa ang imong mahimong partner sa contract of partnership, ha. Dili po ka pwede pugson by another person nga magpartner mo. So dapat it is your right to choose kung kinsa imong gusto nga mahimong partner. So that is the doctrine of Delectus Personae. Basically going back to the characteristic of contract of partnership, which is consensual. Meaning, nagkasinabot mo nga kamoy maghimong partner. So again, that is the doctrine of Delectus Personae. Now we also have a, what do you call this? We have in connection to the doctrine of Delectus Personae, we have this what we call partnership at will. Usually, ang mga partnership na ana sila ibuta nga kanang expiration date kung kanus sila ko to partners. But naay mga partnership nga dili magbutang og term. Dili sila mag-fix kung hantod kanus sila partners. So that is what we call partnership at will. No, kung kanus nila gustong sugdan o kanus nila gusto nga homnon, it may be, it is still valid because the law, what do you call this? The law recognizes partnership at will. And again, we go back to the doctrine of Delectus Personae, wherein you have the right to choose your partner. Excuse me. Okay. So aside from what do you call this? Aside from being a partnership because you want to gain, there's also a partnership when a group of people is exercising a profession. So, unsa man nga mga partnership mo ning mga law firm, auditing firm, accounting firm, or ang firm is daghan na mo. Ang partnership is two or more. So, you can call yourselves um, A and B partnership, whatever. But ang inyong main nga purpose is to exercise your profession. So, pwede gihapon na siya ma-consider nga valid contract of partnership. Ang inyong usually i-contribute diha is ang inyong industry. But nevertheless, mag-contribute maghapon mo para sa inyong office, sa inyong mga operational expenses. So, there is still contribution. So again, aside from a partnership venturing into business, partnership exercising profession is still a valid contract of partnership. Okay, so let's go to Article 1168. It states there that a partnership has a juridical personality, separate and distinct that of each of the partners, even in the case of failure to comply with the requirements of 1772. Now, what do you mean by juridical personality? So, under our law on persons, that is Book 1 of the Civil Code, there are two kinds of persons. Number one, we have natural persons. Second, we have juridical persons. So, who are natural persons? Natural persons are kita, mga tao, who are born as humans by nature. So, we are considered natural persons. Now, who are juridical persons? Unsa man day po ning juridical persons? So, when you say juridical person, no, um, these are entities which are given by the law the right to exercise the rights of a natural person. So, sa may mga rights sa natural person, the right to own property, the right to buy property, the right to disposed property. Mao ni ang mga rights sa usa ka natural person. If juridical person ka, then you also have the right to buy property, dispose properties, sell property. No, juridical person ka, gihatagan ra og personality sa balaod, but nevertheless, you are not a natural person. So, under Article 44 of the Civil Code, juridical persons, the following are considered juridical persons. It includes corporations, partnerships, and other associations. So, basically, a partnership is a juridical person. Lahi siya nga tao. So, si A o si B, they are the partners. The partnership is C. So, si C, different siya nga person from A and B. So, separate and distinct ang personality sa partnership from the personality of the partners. So, unsa man ning 1772? Unsa may giingon? Nga bisag wa naka-comply sa 1772, the partnership still becomes a juridical personality. So, 1768 in your book says it is judicial personality. Let's look at the codal provision. Okay. Actually, under Article 1168 of the New Civil Code, mo ni ang New Civil Code, gamay ra ni siya, but puro ra po ni articles, why explanation. So, I think that is a clerical error, judicial, but actually under 1168, the partnership has a juridical personality. So, juridical na. So, bisag wa sila naka-comply sa Article 1772. Unsa man din ang Article 1772? If a contract of partnership has a capital of 3,000 or more in money or property, then they shall have a contract of partnership in a public instrument. So what do you mean by contract of partnership in a public instrument? It must be notarized and then recorded in the Securities and Exchange Commission. But again, second paragraph of 1772 states that despite the failure to register your partnership with the Securities and Exchange Commission will not affect the liability of the partnership to third persons. So, bisag wa mo naka-register as partnership, but ning transact mo to other people as a partnership, then you are held liable. The partnership becomes a juridical personality despite the failure to register with the Securities and Exchange Commission. So again, nga naman, kay ang registration sa Securities and Exchange Commission is not an essential requisite for a contract to be considered a partnership. Okay? So, ano si Ja? That is 1768. You may read the examples on artificial persons or juridical person. Okay. So, 1169. These are the rules to determine whether a partnership exists. So, there are four rules. No, there are four rules. So, rule number 1, that is what we call, rule number 1 states that persons who are not partners as to each others are not partners as to third persons, no? So, if dili mo partner, if si A o si B, dili sila partner, and then in transact silang duha ni Z, pero they are not transacting as partners, then they are not considered as partners. They are considered as individuals transacting with Z. Kaya wa man sila niingon nga, ako si A, ako si B, partners me. So because they do not present themselves as partners, then definitely it follows nga sa third persons, they are not considered as partners. However, there is an exception to the rule. That is what you call partnership by estoppel. Gusto mo ng partnership by estoppel. For example, si A ug si B, di sila partners. But, pag transact nila ni Z, ingon si A ug si B nga, Z mo transact mi nimo kay partners me. So, bisag wa sila contract of partnership, nagkasinabot na sila then and there nga partners tahay sila nga mo transact with Z, they are now considered partners under the law, under the principle of partnership by estoppel. So, tungod kay ilang gi-represent themselves as partners to third persons, they can no longer deny nga di man mi partners. When in the first place, they presented themselves as partners. So, mo na itong gitawag nga partnership by estoppel. They are not really organized as partners. Wa jud sila contribution. Wa sila purpose to gain together. But because they presented themselves to third persons as partners, then they will be liable as partnership. So later on, you will realize nganong naamay partnership by estoppel. So we just define what is partnership by estoppel, and then later on in the preceding chapters, diha na nato ma-realize nganong gihimo ni si sa balaod. Okay, the second rule on partnership, co-ownership or co-possession does not itself establish a partnership. So, saan din ang co-ownership? For example, na ay parents, and then naa sila na po kaanak. Pagkamatay sa parents, tanan nila properties goes to the napo kaanak. If dili pa ni tunga-tungaon sa napo kaanak ang property sa ilang parents, they are considered co-owners. Pero if co-owners mo, it does not equate into partnership. Nga naman, co-owners raman mo, di man mo considered nga partners. So, number one, ang partnership, it is created by a contract. Meaning, nagkasinabot mo nga mahimo mong partners. Ang partnership. Ang co-ownership, usahay, created by contract, if nagkasinabot mo nga, kitang duha tag-ija ani, but most of the time, it is created by law. Like, for example, ato mga magsuon, nga napo kabuok, the moment their parents died, was sila choice but to become co-owners of the properties of their parents. A partnership has a juridical personality, while a co-ownership does not have a juridical personality. So, if mayroon kang juridical personality, ang partnership pwede ikiha. Kung ikiha ang partnership, it does not automatically mean nga gikiha pod personally ang partners. Kay sa ato bang giingon sa previous nga article 1168, separate ang personality sa partner o sa partnership. So, kung ang partnership ray ikiha, ang partnership ray liable. Pero if ang partner ang ikiha, ang partner apoy liable. But a co-ownership does not have a juridical personality. Wa si jay specific name, dili siya pwede pod makiha. And then the purpose of partnership, of course, we said, di ba, in the essential requisite, the purpose is profit, gain, kita, no, ginansya. But the purpose of co-ownership is common enjoyment. Kita lang tanan tag-ija, but not necessarily profit. And then, so, muna, stipulated jud always ang profit in a partnership. However, sa co-ownership, dili pwede nga naay nga kanang for example, sa partnership, pwede nga ang inyong sharing sa kita is 60-40. Inga na, or 50-50 lang mo tanan. or equal ra mo. But in a co-ownership, kung pila imong ownership ana nga property, maura gajud na imong share. So if you only own 10% of the land, maura pud na imong makuha nga share. Unlike in a unlike in a contract of partnership, bisag for example 10% ra ang imong na contribute pero moingon imong partners nga 50-50 mo sa kita, then it is alright. Unlike in a co-ownership, that is not allowed. And then the solution, how do you dissolve? So a partnership is dissolved by the death or incapacity of a partner. So the moment a partner dies or incapacitated, dissolve ang partnership. However, in a co-ownership, the death or the incapacity of the owner does not dissolve the co-ownership. And lastly, form. A partnership may appear in any form. No, pwede ra mo magsabot, verbal, pwede po registered under the Securities and Exchange Commission. And then, sa co-ownership, there is no form needed. There is no form needed. So, may difference sa co-ownership ug sa partnership. And again, co-ownership is not equal to partnership. So, rule number 3, so the sharing of gross returns does not itself establish a partnership. Nga naman, gross returns is different from net profit. So, unsa man day i-share sa partnership, dili ang kapital ang iuli, but ang kita sa kapital. So, ang profit na ang ginansya ray injong tungaan, dili ang injong gihatag nga contribution. So, again, we said, di ba nga, the main purpose of creating a partnership is for profit. So, kinahanglan, ang inyong sharing is on the net profit and not the gross returns. And then, rule number 4. Okay, rule number 4, it states there that the receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in the business. So, if ang usa ka tawo ning dawat siya sa ginansya sa business sa partnership, that is prima facie evidence, no? That is evidence in itself nga partner siya sa business. So, bisan for example, og kanang wa imongan dito sa A, B, and C partnership, kay ikaw si letter D, but ning dawat ka sa share sa ilang kita sa partnership, then by presumption of law, you are considered a partner. However, they may, because it is only a presumption of law, they may prove or present evidence na indeed you are not a partner. However, there are many exceptions to rule number 4. So, pwede nga mudawat ka sa share sa profit but you are not considered a partner. What are the cases of this? What are cases under this exception? So, number 1 exception is if you receive the profit because it is a payment of a debt. No, bayad ang profit nga imong nadawat, dili gyud to siya profit, but bayad to sa utang sa partnership kay nakautang ang partnership nimo mo nang ang kita sa partnership gihatagan ka og share. So if utang ra to, if you are only a creditor, then you are not considered a partner. Second, if it is only in the form of wage, sweldo ra to. So naay kita ang partnership, nagtunga-tunga ang mga partners. Ang sweldo sa empleyado nga gi-charge dito sa profit sa partnership, and then gihatag sa empleyado ang sweldo, it does not necessarily make the employee a partner. Or if ang gibayad sa renta sa building is gikan sa profit sa partnership, ang landlord, no, it does not make him a partner because ning dawat sila sa profit sa partnership. Third exception to the rule is as an annuity to a widow or representative of a deceased partner. Prior to dissolution, before ma-dissolve ang usa ka partnership, nasa liquidation. So, unsa man liquidation? Tanawon kung pila ang assets, minusan sa liability, and then mao na laman ni ang nabilin. Sa pagtunga-tungaan if ang partner, if for example, na-dissolve ang partnership tungod kay namatay ang usa ka partner, ang hatagan sa share atong patay nga partner is ang ijang widow. So, isang surviving spouse. So, bisag gihatagan si surviving spouse og share sa profit sa partnership, it does not mean that the surviving spouse is a partner. Number 4, if the share of the profit is as payment of an interest on a loan. So, basically, pareha sa number 1, no? Bayad sa utang. So, if ang creditor sa partnership bayaran gikan sa kwarta sa profit sa partnership, it does not make him a partner. And then, lastly, number 5, as consideration for the sale of goodwill of a business or other property. Now, for example, ganahan mo palit ang partnership o property or goodwill ngan sa business ilang gustong paliton. Then, ang ilang gamiton nga kwarta is ang katong profit sa partnership. So, ang katong kwarta nga ilang gigamit pamayad, kung kisa to ilang gibayaran, of course, it does not make those persons partners despite the fact nga nakadawat sila og share sa profits of the partnership. So again, under rule number 4, when a person receives a share of the profit of the business of the partnership, automatically may i-presume sila sa balaod nga partner sila. Except if the person who receives the share of the profit falls under the 5 exceptions. Okay. So we have Article 1170. Okay. So Article 1170, of course, it states there that a partnership must have a lawful object or purpose. So, as you learned in your law on contracts, a contract with an illegal purpose is considered void. No, so dapat, of course, lawful purpose or object ang reason nga nung nag-create mo og partnership. No? So, for example, himo mo partnership and then ang inyo business nga venture is drugs or smuggling, no? So, that is not considered a lawful partnership. Now, what happens if your partnership is when your partnership is ruled by a judicial decree that it is unlawful? Moingon ang korte nga unlawful ang inyong partnership. So, number 1, what are the legal effects? Number 1, of course, as we have said, the contract is void ab initio. Void from the very beginning. Okay? As we have said, ang usa ka contract nga illegal ang purpose, automatic dyan na sa void. Second, if naa may mga profits ato nga partnership, ato nga business, it will be confiscated in favor of the government. So, tanang kita sa partnership nga illegal, maadto sa gobyerno, including ang mga properties. Properties. Instruments, tools, and proceeds of the crime. So, any gamit sa partnership nga gigamit nila illegally, maadto pod na sa gobyerno. However, if ang contribution sa partner is not used in a crime, then it will not be confiscated by the government. Basically, 1170 talks about the effects of an unlawful partnership. Okay. 1771 talks about the form of contract of partnership. Unsa man dapat nga form? Naabot ay format kung gusto ka mahimo nga partner. So general rule, no form is required. However, there is an exception to the rule. So general rule, why form? You can be partners through oral nga agreement. You can also be partners by having a written agreement. Pwede private nga instrument, injo lang sinabutan. Pwede po mahimong public, injong ipa notaryo. However, there are exceptions to the rule. If the partners contribute real property, so meaning real property, buildings, lands, houses, no? If mga real property ang ilang i-contribute, then it must be written in a public instrument. No, dapat na public instrument if real properties na ang gi-contribute. If there is no written instrument wherein ang contribution is real property, then the contract of partnership is void. Okay? So, moro ni sa exception. Pwede ra mo magsabot kung dahil nag nag-amutay ra mo tag 2,000. No, 2,000 si A, 2,000 si B. So, nagsabot sila nga partners tamo ni atong himoong capital. So, 4,000. Because what they contributed is money and not real property, then pwede nga why public instrument. But if ang gi-contribute sa partners or land, no, juta ang contribution, there must be a public instrument to that effect, and without the public instrument of contract of partnership, it is considered void. So, kinahanglan lang written in a public instrument if real properties or real rights are involved. Okay. So, again, general rule, it may be constituted in any form. So, 1772, I mentioned this earlier. If ang capital is 3,000 or more, money or 3,000 worth nga mga personal properties, it must be registered with Securities and Exchange Commission in a public instrument. However, if dili ma-register sa partners ang ilang partnership with the Securities and Exchange Commission, valid gihapon ang contract of partnership. But if the capital is katong real property, kinahanglan jud nga public instrument, otherwise it will become void. If the partnership capital is below 3,000 and personal property only, pwede ra nga Y registration, and it may also be verbal in a way. Okay, so why is there a need for registration with the Securities and Exchange Commission? It is a form of a business license, no? If ganahan ka maghimog business nga ikaw ra sole proprietor ka, you register with DTI. But if partnership ka nga business, you register with Securities and Exchange Commission. And if corporation ka, you still register with Securities and Exchange Commission. So, mo na ang purpose sa registration. Okay. So, Article 1773, as I have said earlier, void ang contract of partnership when the contribution is a real or an immovable property. So, dapat na inventory sa properties attached to the public instrument. So, again, maura ni ang exception to the rule sa form sa contract of partnership when the contribution involves immovable or real properties. Okay. So, any immovable under 1774, any immovable property or an interest therein may be acquired in the partnership name. So, pwede ang partnership mo palit og juta. No, pwede mo palit og juta, pwede mo palit og buy. So, kung ila pong ibaligja, ang partnership pod ang mo baligja. Dili pwede ang partner. So, if ang tag-ija sa immovable property is ang partnership, then it only follows nga ang makadispose ana nga property is the partnership itself and not the partners. Okay. 1775 talks about secret associations and societies whose articles are kept secret among the members. So, if ang ilang ang ilang, sa may difference sa association o sa partnership, daghan mo ta mga association, sa man ay kalahian. Ang partnership, again, has a juridical personality, while an association, if unregistered, is not considered a juridical personality. And then the purpose of partnership again is profit, while the purpose of association is any purpose other than profit. So, pwede na-associate sila for Mother Earth, association of fishermen or farmers. No? So, lahi og purpose ang partnership o association. And then, sa partnership, again, there is contribution, while ang association, usually membership fee ra. Dili na siya consider nga what do you call this? Contribution, membership fee. And then, liability, because partnership has a juridical personality, then it can be held liable, while in an unregistered association, the members are individually liable because the association itself has no has no juridical personality. So, may difference sa partnership o association. So, lahi ang partnership sa association, lahi ang partnership sa co-ownership. These are different things. So, we go to the different kinds of partnerships. Daghan, there are many kinds of partnership. So, according to object, there are two kinds. We have the universal partnership and the particular partnership. So, sa man yung universal partnership? Two kinds po. Duha ka klase nga universal partnership. There is universal partnership of all present property and universal partnership of all profits. Okay. So, if mayroon ka universal partnership of all present properties, so tanan, si A, B, and C, nag-contribute sila, lain-lain ilang contribution. And then, ang purpose aning all present property nga universal partnership, kung unsay ilang gi-contribute o kung pilay profit because of the said contribution, ila nang i-divide tanan, including the contribution. So, ang ilang i-divide, not just the profit, but the contribution. Whereas in a universal partnership of profit, ang ilarang i-divide is ang profit. So, kung unsa ray kita, mao ray ilang i-divide. Ang katong gipang-contribute nga mga properties, bisag ilang tong gi-contribute sa partnership, at the end of the day, if the partnership is dissolved, it will go back to the partner. Unlike sa universal partnership of all present property, kung unsa ilang gi-contribute to the partnership, o kung pilay unsa ilang gi-contribute to the partnership, if ma-dissolve ang partnership, ilan nang i-divide among themselves. It does not go back to the partners, individual partners. So, mo na difference anang duha. While a particular partnership, specific, no? From the term particular, specific ang ilang business or specific ang purpose or ang undertake unsay gusto mo haton sa usa ka partnership. And a partnership exercising profession is a particular partnership. A universal partnership, it may enter into any kind of undertaking or business as long as it is lawful. Okay. And then, according to liability, we have general partnership and limited partnership. So, unsa man yung general partnership? Tanang partners are considered general partners and they are liable. No, ang ilang liability is equivalent to their contribution. So, kung pila, naka-contribute ka og 40%, 40% ra pod imong liability. So, we will discuss that, the general partnership later on. Compare that to a limited partnership. So, it will be discussed in the last part. No, kay kuan pod, kuyaw pod ning limited partnership. Kana ning A, B, and C, LTD. So, meaning na ay limited. Limited ang partnership. In a limited partnership, ila dyan ang isuwat nga limited. To let the people know nga it is a limited partnership. So, we will discuss that later on chapter 4. And then, according to duration, so I discussed earlier, ang partnership at will, they do not fix a specific term. Kung kano saan nila gustong undangon, pwede nilang undangon. There is also a partnership at a fixed term, meaning, nasa ilang kontrata nga partners ta until 2020. Until December 31, 2020. So, in January 1, 2021, then, automatic nga magsugod na ang liquidation and dissolution process. Okay. And then, we also have a partnership for a particular undertaking. So, for example, in your partnership, ibutang dito, we will remain as partners until we finish Project A. So, the moment nga mahuman ang Project A, because it is only for a particular undertaking, then, the partnership, the moment na mahuman ang undertaking, the partnership will then move for liquidation and dissolution process. So, that is according to, duration. And then we have, according to representation to others, we have ordinary partnership, katong sinabutan, gajud nga partnership, and partnership by estoppel, katong giingon ganina nga, dili mo partners, pero nagpaka-partner mo atubangan sa third persons, then, bisag dili gajud mo partners tinuoray, you will be liable as a partnership. It is partnership by estoppel. And then we have according to legality of its existence, we have de jure partnership. When you say de jure, it complied with all the legal requirements of the law, and de facto partnership. Kung sa maning mga de facto partnership, katuning mga partnership na contribution of personal property 3,000 and above, but naka-register with Securities and Exchange Commission, they are still considered a partnership. However, it is a de facto partnership. Okay. So, 1777, universal partnership na may either refer to a present property or all the profits. So, sa 1778, it discusses there a partnership of all present property. So, motong giingon nga ang contributions of the partners, the properties nga ilang gi-contribute, and the profits acquired by the said properties. So, ilan nang i-divide among themselves, the contribution and the profits. Sa universal partnership of all present properties, the property which belongs to each of the partner at the time of the constitution of the partnership becomes the common property of all partners. So, sa akong giingon, If ang inyong gisabutan is partnership of all present property, the moment nga imo nang gi-contribute ang imong property to the partnership, it is now common. Injo na nang panag-ija tanan, dili na nimo pwede kuhaon at the end of the partnership kay injo naman ang tunga-tungaon. However, there are properties which cannot be included sa all present property. So, unsa man ni? These are your future property. So, dili pwede nga ang imong i-contribute to the partnership is a future property. Meaning, wa pa ning abot. Kaya unsa man ni inheritance, legacy, or donation. Nga naman, kanus man rin mo take effect ning inheritance, legacy, or donation mortis causa upon the death of the donor or the testator. So di ka pwede moingon nga naay kabilin akong amahan, mao ni akong i-contribute pero buhi pa imong amahan. So dili na allowed nga i-contribute in a universal partnership of all present property. So ang imong then dapat mo i-contribute is a property that is owned by you. Dili pwede nga ma-own nimo but in the future. So present jud ni mga nga properties owned. Okay. So mao na. So may difference ana sa universal partnership of profits. So ang universal partnership of profits, it comprises all the partners may acquire by their industry or work during the existence of partnership. So usually, for example, kasagaran ng partnership, universal partnership of profits, if gi-contribute ang partner to the property, to the partnership, if ma-dissolve ang partnership, mobalik sa partner ang ownership. Dili pareha sa all present property nga the moment nga imo nang gihatag sa partnership ang property, kamo nang tanan tag-ija. Sa universal partnership of profits, ang injo ra gud yung tunga-tungaon as partners is ang kita ra, but ang properties contributed still belongs to the partners, individual partners. So again man nilang difference, no? Ang partnership of all present property, ang imong gi-contribute, it is owned by the partnership, commonly owned. So, kamo ng tanang partners ang tag-ija. Unlike in a universal partnership of profits, imo rang gipa gamit ang imong property ug unsay kita ang property, but at the end of the day, imo gihapon ang ownership sa property. Okay. Muna siya. And then, in a universal partnership of property, the profits of said contributed property becomes common property, but not profits arising from other property of the partners. So, for example, si partner A, na si Zay gi-contribute nga juta. But, napo si Zay laing juta. Kung unsa nga property ang isang gi-contribute, katura ang tunga-tungaon sa mga partners, except kung stipulate sa contract of partnership nga other properties of the partner, even if not contributed to the partnership, makatag-ija pod sa profits ang mga partners, but that is unlikely. And then sa universal partnership of profits, only profits acquired becomes the common property. Profits acquired, not the property itself. Okay. 1781, Articles of Universal Partnership entered into without specification of its nature only constitutes a universal partnership of profits. So, if in your Articles of Partnership, dili ninyo specifically ibutang nga this is a universal universal partnership of all present property, automatically i-presume sa balaod nga it is only a universal partnership of profits. Nga naman, because the universal partnership of profits is less onerous compared to the universal partnership of all present property. Less onerous meaning dili siya kaadyo burdensome. No, dili siya kaadyo bugat kumpara sa all present property. Nga naman, kaysa all present property, tanang properties nga contributed, kamo ni tag-ija tanan. Unlike sa profit nga, kung unsa lay kita, mao na to'y injong tunga-tungaon. So, kung dili ninjo, ibutang sa injong articles nga it is a universal partnership of all present property, then it is automatically presumed nga it is a universal partnership of profits. Okay. 1782. Persons who are prohibited from giving each other any donation or advantage cannot enter into a universal. So again, under Article 1782, persons who are prohibited from giving each other any donation or advantage cannot enter into a universal partnership. Nga naman, because a universal partnership, basically, naghatag mo og, nag-contribute mo og properties to each other. And you are not allowed to donate, no, to each other. Nevertheless, you are not also allowed to enter into a universal partnership wherein you contribute properties for each other. So, kaysa may dili pwede mag-enter into a universal partnership, number one, legally married couples. So, ang mga mag-asawa, they cannot enter into a universal partnership. However, they may enter into a particular partnership. Pwede sila nga ma-enter into a partnership in the exercise of profession. If dili pwede ang mag-asawa, dili pud pwede ang mag-live-in, or we call common law spouses. Persons living together as husband and wife without a valid marriage. Di mo ganing pwede ang mag-asawa, more so ang common law spouses. And even more so, persons who are guilty of adultery or concubinage. So na, mga kabit, dili pud pwede mo enter into a universal partnership. Persons found guilty of the same criminal offense in consideration thereof, criminal offense, guilty na sila sa adultery or concubinage. And a person or persons and a public officer or his wife, descendants, and ascendants by reason of his office. So, dili pod pwede mag-partner ang usa ka private person ug ang usa ka public officer or ijang wife or ijang anak or parents. Tungod, if ang reason nga nung nag-partner sila is tungod kay ang usa ka and lastly, a person or persons and a public officer or ang family sa public officer. So, a private person and a public officer or family sa public officer, dili pwede mo enter into partnership if ang main purpose nga nung ni-enter sila into partnership is to gain advantage because one of the partner is a public officer. So, dili po na pwede sila mo enter into a universal partnership. And lastly, for Chapter 1, we have 1783. A particular partnership has for its object determinate things, their use of fruits or specific undertaking, or the exercise of a profession or vocation. So basically, it defines what is a particular partnership. So kung dili ka masud aning particular partnership, then you are considered a universal partnership. Basically, that is Chapter 1, the general provisions on the law on partnership. If you have questions, you may do it in our, or questions or clarifications, you may send your questions or clarifications in our group chat. So that's all. Good night. Eds.